Ready, start. He submitted that complaints do not make out any cognizable offense and are barred by section 197 CRPC, as whatever acts have been performed by the officers, they were in discharge of their official duties. Complaints are also hit by section 140 of the Delhi Police Act 1978 and are barred by limitation. Admittedly, the CBI was a party in the writ petitions before the High Court and had not chosen to assail the impugned orders, meaning thereby that the CBI never felt aggrieved by the said orders. The CBI, even if impleaded, would be added as the respondent or a pro forma respondent. It is well recognized in law that a respondent or a pro forma respondent may support the judgment impugned but cannot assail the same in his capacity as a respondent. The CBI has not independently challenged the aforesaid orders of the High Court. Moreover, the CBI is not the party actually aggrieved by the direction given by the High Court for the registration of the FIR against the two officers. It is the officers who are aggrieved in their personal capacity and not the institution to which they are on deputation. It is therefore for the officers to defend themselves by taking appropriate legal remedies, and the CBI has nothing to do with it. This apart, the report of the CBI is not under challenge, therefore, the contention that CBI has to support the report of its officer is not appreciable. Accordingly, we do not deem it necessary to permit impleadment of the CBI and to consider any objections as raised by the learned Additional Solicitor General. The plain reading of the impugned judgment and orders of the single judge of the High Court dated 26/6/2006 reveals that the officers of the CBI in the dock have committed irregularities, if not illegality, in discharge of their official duties and are prima facie guilty of the commission of the offences as alleged. This is clearly reflected from the averments contained in the complaints and the petitions. Both the officers have acted in connivance, and it is alleged that one of the officers, Vinod Kumar Pandey, had acted at the behest of the senior officer Neeraj Kumar. The question whether Vinod Kumar Pandey acted on the advice or behest of Neeraj Kumar or whether they were in connivance is a matter of fact which has to be investigated. The single judge of the High Court in writ petition with bracket criminal bracket close number 738 of 2001, upon consideration of the material on record, including the inquiry report dated 26/4/2005 of the Joint Director of CBI, found that cognizable offences were prima facie made out against the officers of the CBI, that is, the appellants. The allegation that the documents were seized on 26/4/2000 without preparation of the seizure memo stood substantiated even in the inquiry report, which recorded that the memo of seizure was prepared only on 27/4/2000 and not at the time of seizure on 26/4/2000.